Just a quick word on the distinction between third degree murder and involuntary manslaughter. Now, I've mentioned in my classes, and I imagine Professor Mystic has mentioned in his, that the legal definition between these two crimes is incomprehensible. So let's look at the language itself that defines these crimes. So involuntary manslaughter is described as a reckless killing, and recklessness in this context means a conscious disregard of a substantial and unjustifiable risk to another person's life. All right, defining exactly what that is hard enough. But then let's go and look at the definition of third degree murder. And that that crime in the statutory definition says all other forms of murder are third degree murder. So we have first degree murder described as an intentional killing. We have second degree murder defined as a felony murder. And then third degree murder says all other forms of murder are third degree murder. So that just begs a lot of questions. First of all, the statute itself then doesn't give us a definition. It therefore relies on the common law definition or the definitions that Pennsylvania had used prior to this version of the statute. And those seem to be judicially created definitions of malice. And what exactly are those? How do Pennsylvania courts define this thing that the statute says all other forms of murder other than first and second degree murder are third degree murder? Well, in Thomas and Young, the court says that the following set of terms defines third degree murder: wickedness of disposition, hardness of heart, wanton conduct, cruelty, recklessness of consequence. Recklessness of consequence. Compare that to involuntary manslaughter. Recklessness is the mens rea for involuntary manslaughter. So how can it possibly be that we have a meaningful distinction between third degree murder, one of the definitions of which is recklessness of consequence, and involuntary manslaughter, the definition of which for mens rea is recklessness? So if you doubt for a second what I've been saying in class, that these homicide statutes create distinctions that no reasonable juror who for the first time comes to a homicide case and has to resolve, you need to look no further than the fact that third degree murder is defined in part with one of the same definitions that's used to describe involuntary manslaughter. So this is what we give jurors. Obviously with involuntary manslaughter, there's only recklessness, and then there are other words that accompany recklessness in the third degree murder jury instructions. But wow, what do you do with that? What do you do with that if you're a juror? So this just is offered to show that we put a lot of faith and trust in juries to grade homicide, to tell us how bad it is. And what information do we give them to distinguish between third degree murder and involuntary manslaughter? And we give them definitions that contain in part the same words. So this is my kind of really critical analysis of how juries are supposed to go about resolving where on the continuum between third degree murder and involuntary manslaughter a particular set of facts falls.